object to consideration of the concealed carry resolution number 08-419. This is an emotionally charged and divisive issue tainted with anti-governmental paranoia and racial overtones. It is also one with both statewide and national implications, devoid of any exclusive impact upon the residents of Will County regarding its consideration outside of our legislative authority. The attention, efforts, resources, and time of this body should be restricted to matters that are unique to Will County, and to do otherwise is to set a bad precedent for our future county boards. Thank you. Moreover, the proponents of this resolution are aware that the matter is already before the General Assembly by order of the Court of Appeals for the 7th Circuit. This is where the issue should remain, as it is at this level of government where action of any real consequence can take place. The appropriate place for proponents to express their sentiments is to the General Assembly, not here. To begin indulging such issues at this level of government constitutes little more than pandering to the interests of the weapons manufacturing industry and pandering to anti-governmental sentiments. If we insist upon this disservice to the people of Will County, then at least they should be spared disinformation about the history of the Second Amendment, its judicial precedents, and disregard of relevant facts. Therefore, I wish to take a few moments to share with you what I have learned about the Second Amendment and guns as a student of history, an attorney, and from my empirical experience as a retired supervisory special agent for the federal government with over 20 years of law enforcement experience. I would like to take a few moments at this time to make my statement with regard to the support of my motion. Do I have that time?
2 minutes. 2
minutes.
Take your time. 2 minutes.
Hold on. This is a very controversial issue. We understand that, but please, I would appreciate your patience on this. As a member of the committee, he is not constrained by time limits as everyone else is here. So, again, Mr. Bible.
Thank you, Mr. Chairman. With respect to judicial precedents, even Judge Richard Posner, who wrote the decision of the 7th Circuit in the Moore versus Madigan case, stated that the Heller case created a federal constitutional right that did not previously exist, specifically that the Second Amendment gives the individual the right to keep and bear arms without connection to service in a militia. He further admits that in having found such a right, Justice Scalia, who authored the majority opinion in this split 5-4 decision in this 2008 Supreme Court case, would have yielded the opposite result had he adhered to his purported judicial philosophy of original interpretation. However, Justice Scalia did not stick with the original interpretation of the Second Amendment. In finding that there was an individual personal right to keep and bear arms, not affiliated with state-regulated militia, he broke with over 200 years of legal precedents to the contrary, including 3 previous Supreme Court rulings, the last ones being 70 years earlier in the case of U.S. versus Miller back in 1939. Prior to Heller, the Supreme Court had held that the right to keep and bear arms had to be in conjunction with service in a militia. And the precedents for that are Cruikshank of 1876, Presser, which is an Illinois case of 1886, and the Miller case of 1939. Nevertheless, Justice Scalia did confine the right to keep and bear arms to private use at home, noting, quote, the majority of the 19th century courts to consider the question held that prohibitions on carrying concealed weapons were lawful under the Second Amendment or state analogs. And he explained further that, quote, nothing in our opinion should be taken to cast doubt on long-standing prohibitions, end quote. This resolution is nearly devoid of any rational prohibitions or regulation regarding the types of ammunition used, types of weapons that can be carried. It also fails to talk about transfer of guns. It fails to talk specifically about any training requirements. The resolution is nearly devoid of any of that, and it doesn't speak to background checks as far as I can see. It was the appellate court for the 7th Circuit by a 2-to-1 split decision that rendered Moore versus Madigan, just last December, the right to keep and bear arms, which extended beyond the home to permit the carrying of concealed weapons pursuant to the Second Amendment. The Supreme Court has yet to rule on the matter. However, I emphasize that both the Supreme and Seventh Circuits were nearly evenly divided on these respective extensions of this right. Then on February the 22nd, 2013, the appellate court for the 10th Circuit weighed in on the matter of concealed carry with a unanimous decision. And in that case of Peterson versus Martinez, the court said, quote, "We first ask whether the Second Amendment provides the right to carry a concealed firearm. We conclude that it does not." End quote. The Supreme Court had rendered a similar decision in Robertson versus Baldwin back in 1897. So what is the history of the Second Amendment? Well, even Seventh Circuit Court Judge Richard Posner has stated, quote, "The purpose of the Second Amendment, judging from its language and background, was to assure the effectiveness of state militias," end quote. To state that the purpose of the Second Amendment was to arm the citizenry so that it could protect itself from a potentially, quote, "tyrannical government" is to distort history. The majority of historians on the matter conclude that the reason for this amendment was ostensibly to protect us from a standing army, while also providing for a well-armed militia that could be quickly called in time of need, as turned out to be the case in the War of 1812. The Founding Fathers were dubious about standing armies, as is evidenced in the fact that you can't fund an army for more than 2 years in Article 1, Section 8 of the Constitution. Therefore, those first 4 words of the Second Amendment, "a well-regulated militia," gave the government the right, the power, and duty to produce regulations governing the militia and providing for the security of the state and safety of all citizens therein. It was concerned with empowering government to put down insurrections, such as the one that took place in western Massachusetts from 1886 to 1887, contiguous with the drafting of the Constitution. And this rebellion, this insurrection, came to be known as Shays' Rebellion. This is what the Founding Fathers had in mind: the putting down of insurrections and the repelling of invasions, such as that which we experienced again in the War of 1812 from the British. However, more specifically, and this is what people seem to little know, the Second Amendment was a measure taken by its drafter, James Madison, in an effort to alleviate the concerns of Southern Founding Fathers about the preservation of slavery and ensure ratification of the Constitution by Southern states. At the time that Madison drafted Article 1, Section 8 of the Constitution, which invested most of the power over militias in Congress rather than the states, the South feared that the institution of slavery would end. Southern states called their militia, quote, "slave patrols," which were charged with the duty to conduct slave inspections, prevent escapes, and stem slave uprisings. Therefore, Madison took immediate measures to appease the South with a Second Amendment to the Constitution, in which he used the term, quote, "state" instead of country, and imbued them with the power, and imbued Congress with the power to, or the states rather, to avail themselves of the services of these armed militia. Well-regulated militias meant that slaves could be kept in chains, thanks to the Second Amendment. This was not about arming those who were at the time considered to be, quote, "citizens," against a potentially tyrannical government. Finally, I'd like to emphasize that all the statistical reports that I've ever seen in my 20 years as a federal agent concluded that in excess of 30,000 annual gunshot deaths in this country a year are mostly due to firearms that were lawfully obtained, that most discharges from them struck a human, the victim was the owner, a member of the owner's family, or an innocent bystander. Perhaps you'd be against any proliferation of guns if, God forbid, you had to lay a person to rest who was a member of your family or seriously injured by a gunshot, as my family has experienced. If gun proliferation were the answer to the gun violence, then America, which constitutes 4% of the world's population and over half of the private gun ownership in the world, should be the safest place on earth. Instead, more of our children are killed by gunfire each year than are killed in the war zones around the planet. Therefore, I urge the members of this committee to vote yea on my motion to refuse to consider this question. And let's move on with the real business of Will County.